Kia ora, everyone. I'm Yevgenia Chityan, and I'm the Business and HR Advisor at Retail NZ. Some of you may recognize me. You may have emailed me or called me up on the advice line. Today, I'm very excited to present our webinar, which is an employment law masterclass on restructures and redundancies. I'm joined today by Eloise Sharpe, lawyer, and Jordan Todd, associate, both from our partners at Ford Sumner Lawyers. Welcome to both of you. Thank you so much for being with us today.
Thank you very much for having us here.
So just before I hand it over to you for your excellent presentation, I just want to have a few notes for our participants. We are recording this webinar and it will be published on our website and social media in the coming days. If you have any questions for our panel, please pop them into the chat and we will find opportunities to get those answered for you. We're also going to send out the slides from today's presentation to everyone who's registered for the webinar. So just keep an eye out in your inbox. We'll be sending those out very soon. And without further ado, I will hand it over to Eloise and Jordan.
Brilliant. Thank you very much, Ev, and thanks to everyone for being here this afternoon, wherever you're joining us from around the country or indeed outside of the country. So as you've pointed out, my name's Jordan Todd. This is my colleague Eloise Sharpe, and we're both from Ford Sumner Lawyers. Ford Sumner is a law firm based in Wellington. We're founded about 20 years ago, and we've got a team of just over 20. And as it says there, we're specialists in a few different areas, namely dispute resolution, corporate and commercial law, commercial property and construction, and for today's purposes, employment law. And so we're pretty well placed to assist retailers with a range of legal issues. We've been doing that for the past year as proud legal partner of Retail New Zealand, through which we offer Retail New Zealand members discounts on the legal services that we provide. So that's just a bit of a background and who are we, if you will. In terms of what we're going to discuss today, obviously as the cover slide suggests, we're talking about workplace restructures. And when we were thinking about the sort of topic we could talk about today, really the first thing that came to mind was restructures and redundancies, simply because we're seeing it so much at the moment and really since COVID, to be fair, but in particular over the last 18 to 24 months, principally just due to the prevailing economic conditions in New Zealand, which as retailers you'll all be well aware of. We've seen and assisted a lot of retail clients with restructures, but outside of that as well, we've really seen restructures across the board, and so we've been involved in workplace change processes for clients, in the real estate industry all the way to the aviation sector. So today's agenda, we're going to talk about and define what a workplace restructure is. We're going to talk about when you can carry out a restructure. We're going to talk about how to get the process right. We'll touch on redeployment and failing any redeployment opportunities, how to effect a redundancy or multiple redundancies. We'll look at the common pitfalls that we see in workplace restructure processes, and then we'll end with a Q&A. So please, by all means, if you've got any questions throughout the presentation, please feel free to submit them and we'll be happy to answer them at the end. So really the overall aim of today is to show you how to lawfully carry out a restructure, how to genuinely justify redundancies and fundamentally how to reduce the risk of your employees being able to bring successful personal grievances against you as much as possible. So without further ado, what is a restructure? Well, the first point it's important to make is really just a distinction between workplace restructures, which is the topic for today's session, and restructuring as it's defined in the Employment Relations Act. So restructuring under the Employment Relations Act is a slightly distinct concept It basically refers to situations where your business is perhaps sold, you perhaps contract out all or part of your business, or you might actually contract in and bring in-house certain services or a certain part of your business that you'd previously contracted out. So if you're familiar with your employment agreements, as hopefully you all are, you will hopefully see some provisions in there that are titled employment protection provisions. And those basically relate to restructuring as defined under the Employment Relations Act. So we're going to talk about a slightly different and perhaps broader or more amorphous concept today, which is workplace restructures, which basically can be defined or described as any sort of organizational change made to improve a business's efficiency. And that might involve new roles being created. It might involve job descriptions or roles being altered. It might involve multiple roles being combined or amalgamated. And of course, it often involves roles being disestablished, and that's going to be a key focus for us today because, as I said at the outset, it's what we're seeing a lot of at the moment. So a lot of the time, restructures and redundancies are kind of conflated. But as you can see, it's more than just a case of restructures involving roles being disestablished. So even though we'll focus on that, it's important just to distinguish the two terms. So what is required when you are considering and then carrying out a workplace restructure? The way we sort of conceptualize it or think of it is there's two sort of key things to think about, or two parts of the overall test that you have to satisfy as an employer. So the first part is contained in that left-hand column, and we think of it as sort of the what. So what is your business reason for carrying out or wanting to carry out a business restructure? And then why have you selected the particular role or roles within your business to be subject to that restructure? So that's the first side of things. It's what we call the what, and that's what I'll be addressing first in this presentation. And then on the right, we have the how. So you've got all your sort of ducks in a row in terms of what your restructure is going to look like and why you're undertaking it. And then how do you actually go about the process? And that's what Eloise is going to speak to. And that involves consulting with affected staff and then exploring redeployment avenues if there are any, and always remembering that redundancy, if that's what your restructure might involve, should always be a course of last resort. So that'll be the second part of the webinar today that Eloise will take you through. So without further ado, jumping into the first of those two considerations, if you will, looking at business justification. So this is, as I say, sort of the first limb, and there's an inherent tension between an employer's fundamental right to structure their business as they see fit, and that's kind of in tension, or it's always challenged by the idea that if you want to restructure your business and you're going to affect certain roles, then you need to have a genuine business reason for doing that. Now, historically, the court said, look, it's up to the employer. We're not really going to look too closely at the reasons that you might have as an employer to restructure your business. That's changed over the years, and the philosophy is now much more, or actually are willing to have a look and really closely assess the reasons that you've put forward for restructuring your business, particularly when you're looking at making one or more roles redundant. So the court is definitely willing to put your reasons and your justification for doing a restructure under the microscope. And we've seen that within sort of the last 5 to 10 years in particular. So it's really important to be aware of that. The key point, and one we often see both clients and just employers in general get tripped up on, is the fact that restructures aren't an opportunity to exit problematic staff. It's often quite an attractive idea when you have a staff member who's maybe underperforming, or just for one reason or another isn't a good fit, or there might have been some disciplinary issues, to get rid of them through a restructure. It's often seen as sort of a less adversarial or sort of direct way of dealing with those sorts of problems. But ultimately, those are what we call sham restructures, and you can get in real trouble as an employer when you elect to carry out a restructure for those reasons, and those reasons are discovered. So ultimately, when you've got an employee who's underperforming, or you've got an employee who is being a bit naughty, or they're just not a good fit for your culture, there are other approaches that you should be taking to deal with that, like performance improvement plans. If the conduct is bad enough, disciplinary action, or just more bespoke approaches to dealing with any sort of bad fit issues, if you will. So we've listed some of the genuine business reasons that we often see when restructures are approached in the correct manner. So things like a business losing key suppliers or markets. So we had a client who lost a key supplier in the South Island and wasn't able to replace that, and so the South Island manager role within that business was effectively no longer required, and so that was the subject of a restructure. Changing business processes, we're seeing this more and more, particularly in terms of the amount of work that can now be automated. So certain roles are just now superfluous to businesses' needs, and it's quite common to see roles on the chopping block, so to speak, because there's just more efficient ways of carrying out the duties that the role would traditionally have done. And then, of course, financial challenges, which unfortunately many of you will be quite familiar with in recent months and years. And so, businesses looking to cut costs and perhaps downsize, and looking at things like payroll and reducing that as a way to address those challenges. So those are just a few examples of certain genuine business reasons. It's not an exhaustive list, but just to give you an idea of what you might leverage to carry out a restructure. So once you've got your genuine business reason, you've effectively got to link it to the particular role or roles that you've identified as being subject to the restructure. And the first point there we've got is a question that employees will often ask when sit down and faced with the restructure is, well, why my role? The business might be underperforming, the employee might accept that, but there might be questions as to why it's the employee's position that's being targeted for a restructure, particularly where that restructure might involve that employee's role being disestablished, as opposed to other roles within the business. And so that's why it's really important that selection criteria acts as sort of a logical bridge between the genuine business reason that you've identified, and then the particular role or roles that you have identified as being subject to the restructure. So there really needs to be an alignment there. And again, it's important to avoid subjective factors as the basis for your criteria, like an employee's attitude or an employee's quote unquote fit. There needs to be genuine reasons. So, for example, if your business is pivoting from a brick and mortar store into a more online store focused business, then it would make sense, at least on paper, at a high level, to say, well, we don't need as many customer facing roles within the business, but we might need to keep the IT guy. So that's an example where you've identified a genuine business reason, and then you've tied that to the particular role or roles that you have targeted as being part of the restructure. That's the first sort of stage of the test, the two-step test that you need to satisfy when you're carrying out a restructure. The second, as I alluded to at the outset, is how you go about the process. And process is not pretty key, it's very key. So I'm going to pass over to Eloise. I might jump on every now and again and hopefully add a bit of value, but I'll let Eloise take you through the second part of the test now.
Great, thanks Jordan. So the first part of the process is the information step. So this is key because the employees need to be given all relevant information, or all information that's relevant to the continuation of their employment. This allows the employee to provide fulsome feedback if they would like to. So putting all the information to the employee is really important. So as Jordan said, you've got your genuine business reason, you've got your selection criteria, and then you can put that into a letter to the employee, and you can outline who's affected, why they're affected, i.e. you're going online, you no longer need customer-facing employees. It's really important that the supporting information that you give them substantiates the business case. And you can also outline a time frame in the letter. So you can tell them what date you'd like to meet with them to consult, how long the feedback period will be, when the initial decision will be announced, and then when a final decision will be made. So it's really good to have the timeline there, but just note that it's just a proposal and it may change because you may have more feedback than you initially thought. And in this letter, it's really important to reiterate that no decisions have been made. It's just a proposal, and yeah, you're yet to consider feedback. In practice, what we often do is we tell clients to sit down with their employee before they give them the letter, just to give them a heads up. And then you can offer them to take paid leave for the afternoon so they can digest all the information, and even think about who they might want as a support person to bring to the meeting that you hold with them. So that's the first step of the process. The next part is the consultation step. So in consultation, it's really important to meet one-on-one with the affected employees. This allows them to provide feedback, and it allows you to fully focus on what they want to tell you. So make sure that they know that they have the opportunity to bring a support person, and you can outline step by step the proposal that was written down in the letter, and you can give them the opportunity to ask questions, clarify anything they don't understand, and you can answer those questions. And it's also really good, or it's important to take notes at these meetings, because it's good to have a paper trail of the feedback that was given, and just everything that was said in those meetings, so you can consult or refer back to it if need be. And in these meetings, make sure to constantly reiterate to the employees that no decision has been made. It's just a proposal, and you're wanting to genuinely consider all the feedback that is given. So they'll give the feedback, or they may not. Some employees don't like to give feedback, but some might. And so you want to allow a reasonable time to consider this feedback, or allow a reasonable time for the employee to give feedback. So there should be no less than 2 to 3 working days between when you meet with them and when you make that initial decision. Note that this might change, it's subject to change depending on how much feedback you receive. Then you have to genuinely consider all that feedback, and like I said before, allow a reasonable time to consider all feedback. You may have to extend this slightly if you feel that some employees are really, really engaged and they have lots to say. In other situations, some employees might not want to give too much feedback, and they might be quite happy just to move forward with not much, and that's totally fine. So the next part of the process is to come to that initial decision. If an employee does want to hear more information about the proposal, they may ask for more information. You can consult with them further if you feel like it is appropriate. This could depend on how reasonable the request for the information is, and how reasonable the perceived risk, or if there is a perceived risk of the employee being able to bring a personal grievance if you don't actually engage with them further. So usually it's a good idea to further consult if they'd like to. And just note that you just have to genuinely consider the feedback. You don't actually have to reach agreement with the employee about what they want to be implemented. You just have to reasonably consult with them. So once you've reasonably and genuinely considered the feedback, you can announce the decision. So this will be either to proceed with the restructure, or you can choose not to proceed with the restructure. Today we're going to go on the basis that you have decided to restructure the business. And so you can announce this in a letter and make sure that within that letter you can use your notes here, and you can put the feedback that you received and how you considered that feedback. And it's just outlining to the employees what sort of went into your decision making, which is really useful for them to see. Within this letter, you can invite further feedback regarding potential redeployment opportunities. So there may be redeployment opportunities in some scenarios where you might have another role that could be filled, or there might be situations where there are no redeployment opportunities, such as you've got a cafe and you've decided that you don't want to have the business running on Mondays and Tuesdays because you're just getting less people through the doors, so you need one less barista. So no other roles in the business are really available for redeployment. However, you do still have to invite feedback on this. It's just a necessary step to cover. It may feel a bit token, but it is necessary. So the last step in the process is to make this final decision. So before you come to this final decision, consider the feedback that you may have received regarding the redeployment opportunities, whether there are any or none. Consider that fully, and then you can apply an objective selection criteria for any available roles. If there are none, then you won't have to, but if there are some, then you can look at the skills and experience of the employees and see whether they match the role that you have available. And once you have done that, you can make your final decision. So that could either be redeployment and they can fit nicely into another role, or redundant. So when a role is made redundant, it's important to make it really clear what their notice period is. So often this is 4 weeks. However, check their individual employment agreement, check the employee's notice period and that, and then you can decide whether you might want to pay them in lieu. Often if an employee goes a bit septic during this time, because it can be quite a difficult time, you may want to pay them in lieu for their notice period. However, this is subject to what their employment agreement says. So if that's not an option, then you will just have to pay out the 4-week notice period, just like that. And another thing to consider is a redundancy compensation. So it may say in their individual employment agreement that they're entitled to compensation if redundancy occurs. However, this isn't a requirement, so just check whether it says that in the employment agreement. Another thing to make sure that you include is, or you remember, is their final pay. So make sure that you've paid all statutory and contractual entitlements by the final day. That's really important to get right. And in this final decision letter, when you give it to them, it's really good to outline their support systems that are available to the employees. It could be in-house support. It could also be employment assistance programs and services, just to give the employee an option to go and use those, especially during what can be a very difficult period. It's also really good to offer to include a written reference or verbal reference, or give the employee a chance to ask for one, because they may want to use that when they're looking for future employment opportunities. Lastly, it's really important to remember the human side of this. It's never easy losing a job and being made redundant, so it's really good to be sympathetic or empathetic during this time, and it's good to ask the employee how they want to manage their exit, whether that be an event like a morning tea, or whether they just want to exit quietly. Make sure you ask and see what's going to suit them best. So yeah, that's the process, and I'll hand back over to Jordan.
Brilliant. Thank you very much. And those last 2 points Eloise raised there are actually sometimes the things that employees, when they're quite aggrieved with the process, they'll jump on and sort of raise as being the most problematic aspect of the process, how sort of impersonal it can be sometimes, and how the restructure felt quite sort of lacking or apathetic and sort of lacking in that human touch. So things that can seem like quite obvious or small things, like, you know, as Eloise said, just consulting with the employee about how they want the comms about their departure to go out to the rest of the team. Those can sometimes be the difference between you know, the employee getting in touch with a lawyer or an advocate if they feel quite aggrieved, regardless of how robust the process has been, versus the employee sort of appreciating you know, the job that you've done in making a difficult decision, but making the decision in a really empathetic and fair and caring way. We wanted to sort of reiterate some common pitfalls that we see. So the first thing is, again, as I said at the outset, not having genuine reasons for the restructure. So again, restructure shouldn't be used as an opportunity to get rid of employees who, for one reason or another, you just don't want to have in the business anymore. As Eloise pointed out, sometimes you don't start off on that foot, but throughout the process, the employee can either be quite enthusiastic or maybe a bit overly engaged in the process. We've had a couple of those recently where there is quite a lot of feedback put to the employer, and the employer is sort of bending over backwards to accommodate that. And then, you know, unfortunately, sometimes you just get employees who, I think, as Eloise put it, go a bit septic during the process. And, you know, if you didn't start out on the wrong foot with them, then you can sort of end up in that place. And that can be when, you know, paying them in lieu of them working out their notice period, if that's something you're entitled to do under their employment agreement. That can be a good option, just to sort of draw a line under matters. The second point we had there was vague or subjective selection criteria. So again, making sure you're drawing a proper link between the business reason and the role or roles that you've selected for the restructure. So if the employee says, you know, why me? It's often because the roles and the responsibilities that employee has can easily be allocated or divested to other employees who remain in the business. So a lot of the time, employees will say, well, I'm only on, you know, X amount a year. Why are you not getting rid of the GM or the person who's on twice as much a year as I am? Wouldn't that be a much more effective way of addressing the financial concerns that you've outlined? And taken in a vacuum, that might be the case, but equally, it may be much more difficult to reallocate the responsibilities of the person who is you know, higher up the chain of responsibility, so to speak, than the employee, and that can be a genuine selection criteria. So making sure you're ticking that box as well is really important. Consultation. So Eloise has sort of set out the gold standard for consultation in the process. Unfortunately, we sometimes have clients come to us, or we see it when we're acting for employees who have basically been told one day that, you know, they're being made redundant, and there's no semblance of any consultation process, and that's, you know, real sort of red flag alarm bell stuff for the employer, and really opens you up to a real risk of a personal grievance or unjustifiable dismissal being brought, really regardless of how necessary the restructure might be and how sort of symbolic or token it might feel to go through that process. You still have to, and it's sort of false economy if you decide to cut corners if the employee ends up bringing a claim against you. And then the final point there is just failing to consider redeployment or other alternatives to redundancy if that's on the cards. Again, redundancy should be a course of last resort. So you should always be looking for opportunities to redeploy the employee. And even if there really aren't any, realistically, you've still got to kind of go through that dance, so to speak, and give the employee the opportunity to come up with something. It might be fanciful. And again, as Eloise said, you don't have to reach agreement with the employee. You just have to make sure you're doing what a fair and reasonable employer should do in the circumstances, and giving them the opportunity to sort of make the case. So those are the common pitfalls. And that brings us to the end. I think we're right about on time. We're happy to take any questions, and I think we've had a couple come through since we've started. So yeah, feel free to jump in on those. And before you do, we just again want to reiterate that we're very proud to be Retail New Zealand's legal partner. And if you need any assistance with any employment work, whether it's restructure related or just anything in general, please feel free to contact us through any one of the modes that we've got up on the screen there. And as you'll see, we've also got a Retail New Zealand dedicated email address, so do feel free to get in touch through that as well. Yev, go for it.
Oh, that was a really great overview, Jordan and Eloise, thank you so much. We do have a couple questions, and I've got a few of my own if we have time. But the first one is about providing information to employees about the reasons for the business change. So the question is specifically around what if an employee asks to see more information like financials, for example. And I guess I would just want to add to that question a little bit about how much information is appropriate to share with employees to justify the business reasons for the proposed restructure.
Yep.
Okay, that's a great question to ask. First of all, an employer should give the employee all material that's relevant in terms of the continuation of the employee's employment. However, that's subject to things like commercially sensitive information that it might be inappropriate to disclose, or things that might breach privacy. So as long as you give them all information that's relevant to the continuation of their employment, subject to that commercially sensitive information, or whether it's not going to be good to disclose, but this has to be assessed on a case-by-case basis. So it'll change depending on what information they've asked for.
I think the key is there's no sort of one-size-fits-all approach. And as I sort of alluded to earlier on, the courts have sort of changed their approach to this particular question and been much more willing to say to employers that they need to disclose more. So there's quite a famous case from about 10 years ago where an employee in an accounting firm was made redundant on the basis of financial information that was actually incorrect. And so the employee wasn't disclosed that financial information, and the court found that had she been disclosed, that she would have able to see that, well, actually we aren't operating at a loss and you don't need to get rid of my role. So you've got to tread carefully when employees ask you for more and more information, sure, and be judicious about what you do provide them if there's particularly commercially sensitive information. But equally, the court is much more willing to say, well, no, you can't just put up a roadblock and say, take my word for it, you can't take a look at the books. So it's really not something we say to clients. You can sort of take a one-size-fits-all approach. It depends really, obviously, the reason for the restructure and what the particular information that the employee is asking for, in addition to what they've already been provided, because that will obviously colour the reasonableness of how much information they've been given.
Okay, very good, thank you. And we have another question about what if an employee refuses to engage in the process. And I'm going to add to that another one, which I, on the advice service, have gotten some queries about, which is when employees, what is, to use your phrase, get septic, where they're really making a lot of trouble for the employer during or immediately after the process.
Yep. So if an employee refuses to engage in the process, the employer still has to go through the consultation process, or the steps that should be followed. So you can still offer the employee the opportunity to meet with you and provide feedback, and you can still tell them that you're going to genuinely consider their feedback. It's up to them whether they want to engage in that or not. And as long as you just follow your consultation steps, then that's fine. You can't force an employee to engage, as long as you just take those consultation steps in the right way.
The old adage, you can sort of lead a horse to water, but you can't make it drink. So, I mean, at the end of the day, it's the employees, it's prerogative whether or not they engage, and they sort of can't be given every opportunity to do that and then not do so, and then turn around and say, well, yeah, but you didn't take into account my feedback. at the end of the day, they've got to give the feedback if they're given an opportunity to do so. In terms of the question about becoming a bit septic, I guess the idea of the employer needing to be fair and reasonable and conduct themselves in good faith, that's actually a mutual obligation, so employees need to do so as well. Sometimes employees can be a wee bit maybe difficult, for want of a better word, during the process, and sometimes that sort of justifies taking a few extra steps, whether that's meeting with the employee again, sending a few additional emails just to sort of bolster your paper trail, again, to reduce the risk of the employee being able to turn around and say you conducted the process improperly. But ultimately, if the employee is really being inappropriate, again, that shouldn't be a barrier to running the restructure to its natural conclusion. It just might warrant taking a few sort of bespoke steps to address any funny business or unfortunate conduct on the employee's part.
Thank you. Thanks. Very good. We don't have any other questions in the chat, but I would like to throw in just one more maybe before we wrap it up. I'm not sure how much time we've got for questions.
Go for it. Yep.
I'll throw in one last one that I've been asked about, where sometimes an employer is considering changing a role, maybe not eliminating it, but changing around some of the duties. So for example, if some automation or different processes have been introduced, but some parts of the role are still required, how can that employer tell, how significant of a change to the role does it have to be to where they need to consult with the employee? And is it considered a redundancy or a redeployment, or, what does it look like if their role is significantly changed and they're staying in that role? And if they're not happy with the changes, can you still, after a proper consultation, still implement those changes, even if the employee doesn't like them?
Yeah. There's no sort of one sort of standard way of answering that. There is sort of a threshold that will differ from role to role as to where what is being proposed meets the threshold for a restructure, and then if it's not at that level, then you're looking at probably more a variation of the employee's terms of employment, which should be agreed between the parties. The short answer is that either one of those possibilities will require discussions with the employee, whether that's, hey, we want to adjust your job description to an extent, but not to a level that qualifies as a restructure. You're going to need to get the employee's agreement to that, and then in practice you'd sign a variation to the employee's employment agreement, hopefully with them agreeing. If it's a real and substantial change to their employment, you sort of say changing more than 50% of what their role looks like, you might be changing the title of the role, then that probably looks more like a restructure, which again would necessitate consultation with the employee. So I guess the bottom line is you're going to need to go through a process and have discussions with the employee, regardless of sort of where you end up landing in that example.
Great, thank you. Well, if there's any last questions from anyone, now's your chance. However, if not, then we'll probably close it out here.
And feel free, if anyone thinks of anything after we jump offline, feel free to send through any questions to the email address. They'll be happy to answer that or jump on the phone at some stage.
Right. Well, I just want to say again, thank you so much to Jordan and Eloise. We have really enjoyed having FSL as partners. We refer them to any of our members that we believe would benefit from legal advice, and we'll continue to do so. If you're not sure, you can always give us a call, and obviously you're welcome to contact FSL directly. You can visit them at fsl.nz for more information. And as a reminder, as Jordan said earlier, FSL does offer a 10% discount to members of Retail NZ for their legal services. We really hope that you've enjoyed today's webinar. It is recorded, and we will be sharing both the recording and the slides with those of you who registered for this webinar. A really big thank you also to our other Retail NZ partners whose support enables us to keep you all up to date with everything retail. Ka kite anō. Bye for now.
Thanks, everyone.
Bye.